Good morning. I'm Matt Dana, the managing partner of Dana Whiting Law. Today I'm with one of my partners, Mr. Todd Smith. And Todd runs our trust administration and probate department. And Todd, today we're going to talk a lot about probate, and we're going to talk about trust administration. We're going to kind of compare how they're similar. We're also going to talk about how they're different. But one thing I want to get into right out of the gate is, we're always getting questioned about legal fees. And I can understand why the public in general wants to question legal fees. And, I've hired a lot of lawyers in my career to do different things, and, intellectual property or contracts or whatever. And, nobody wants to overpay for anything. But on the other hand, Todd, there's a real problem if you underpay too. And we get a lot of people that are calling around just wanting to know what a price is. And I just think it's a huge mistake. And I want to talk about some of the problems that a client could run into where paying a cheaper fee could cause a lot of problems. And one thing that I'm thinking about, and I want you to kind of be thinking about this, but I'm thinking about a lot of times these lawyers that quote these lower, cheaper fees, what kind of services do they provide for that, and what kind of service don't they provide? And I kind of want you to speak to that, because I remember you were telling me about some of the probates that you got involved with, where people were telling you that, hey, my prior lawyers never talked about this, or why we have to do that. But the thing that I wanted to talk about on cheaper fees is a lot of times these guys they're a one-person law firm, right? And maybe they don't even have a paralegal, or maybe they do. And I hate to say it, but a lot of these probate attorneys tend to be older. I kind of fit in that category at 66, and I'm kind of the younger end of that probate category. I mean, we know probate attorneys that are in their mid-70s and 80s, and it seems like these guys never retire. But one problem that I would see out of the gate with these guys is they just can't keep up with the workload that they have. Plus, they're maybe not as good at technology and using automation for their forms. And I think I guess what I'm getting at is sometimes a cheaper fee means it's going to be a lot longer process, right?
Right, and more problems can pop up because of the lack of experience in some cases. I usually start the discussion with our clients when I'm talking to somebody that's named as the personal representative of an estate or the trustee of a trust. The first thing I talk to them about is what that means is you are a fiduciary. You have a fiduciary duty. The law is going to hold you to a certain standard, and you owe that duty to other people, that if you breach that duty, they could get litigious, and it could cost you out of your own pocket. And so why be cheap in getting legal counsel to represent you in that fiduciary capacity when you could have somebody that, like you say, if it's a one-man show that doesn't have the same resources we have, maybe doesn't have the same experience, they might see myopic problems, like the only problem here is that this trust owns a property that needs to be sold. And they may not see that it's more than that. It's a fiduciary duty to settle the entire estate, any assets in the trust, and all the way from beginning to end, from marshaling the assets to distributing to the beneficiaries.
Well, I think you were telling me in that one case that you saw where you were talking to a client about, hey, before we distribute anything to anybody, we've got to get a release of liability. We've got to make sure that they're happy with the way you administer this estate, and not and have them release. And we also need to have them maybe waive the requirement for a final accounting. But talk to me a little bit about that case where somebody went through a probate from start to finish and they never got a release of liability.
Yeah, I mean, that's what I mean by start to finish. I mean, we're not just selling a house. We're protecting you from the other beneficiaries of the trust.
Of saying you sold too cheap, or you didn't sell it fast enough, or you...
So we encourage transparency to our client, the fiduciary. We say, hey, we need to produce all the information. We're not hiding anything from anybody. But at the end of the day, before you give somebody, whatever it is that they are rightfully entitled to, you wanna make sure they're okay with what's happened here, you know, and so we don't wanna empty the funds that we have available to us to take care of legitimate estate administration expenses, if this is a beneficiary that's just gonna use that money to sue you and say you've done everything wrong.
Yeah. The other thing is that I see a lot of times where there's a house involved, sometimes there's a mortgage involved too. And you know, the family thinks that they can just keep paying that mortgage and live happily thereafter, and if the bank doesn't know that somebody died, just keep making that mortgage payment. They don't even think about what are we gonna have to do dealing with the bank, and are they gonna rewrite this loan, or am I gonna be able to qualify for the loan? There's a lot of issues that go into that.
And it surprises a lot of my clients when they find out, sometimes they find out that banks will foreclose after
Yeah.
someone's died, you know, and yeah, in most cases, I think it is safe to assume that paying them is gonna keep them happy. But it won't keep them happy forever. I mean, eventually the title needs to be settled.
Yeah. So, you know, this thing about that cheaper is better, I'm saying cheaper probably means is it gonna take a lot longer. Cheaper also means maybe they're not gonna protect you and get the releases and waivers. What other problems do you think about a client that's being, you know, penny wise and pound foolish?
Well, you know, another example that I get a lot is, you know, we talk about giving notice to creditors, both known and unknown. And a very common response is, well, I know we've been through the mail, there are no creditors. Very common response. What they don't understand is that you know, not only is there a requirement, but there's also a benefit to going through the motions of providing notice to unknown creditors. You know, we can shorten the time frame where someone can come out of the woodworks and make a claim. I mean, there's all kinds of reasons why we want to make sure we do proper notices to all known and unknown creditors. And sometimes when you're dealing with somebody that's trying to, you know, be penny wise, you know, you know, maybe they're saving money on legal fees, but they're not getting advice on what they need to be doing about giving notice to unknown creditors.
I've had people that I've talked to say, you know, it's almost like any legal procedure, whether it's a divorce or a bankruptcy or a probate. They think that they can go down to the court, they can get the stack of papers, they fill out the stack of papers, and they file it, and they say, I've done probate, there's really nothing else to do.
Well, I don't know what your experience has been. In my career, every single time, I can't think of an exception where I've talked to somebody about representing them because they're the personal representative in the probate and helping them through the probate process, where they end up, after I talk to them, say, actually, I can do that myself. Then they go and they file it. I've never had that happen where they didn't end up coming back to me anyway,
Right.
because it got too complicated for them, and they needed they eventually came
Well, and
back to me.
sometimes that ends up costing more for you to unwind or correct some,
What
you
was
know,
done
all
wrong.
the mistakes.
Right.
A lot of times I'll say it's cheaper, better, faster for us just to start over rather than try to correct all your forms.
Right.